Am I audible to everybody?
Yes, ma'am.
Yes, ma'am.
Okay. Good afternoon to our guest speaker, respected Dr. Balram Ambade sir, all esteemed dignitaries and participants. I, Manisha Bhoi, Assistant Professor English, on behalf of Government Rajiv Lochan PG College, welcome you all in the second session of National Seminar on Intellectual Property Rights and Research Methodology, organized by Department of Physics and Chemistry. Now we welcome our second speaker of the day to enlighten us all with his knowledge on intellectual property rights and research methodology. So I would like to invite Kameshwar Markande sir to highlight and give a short introduction about Dr. Ambade sir. Over to you, sir.
Okay. Thank you, ma'am. Thank you, Manisha, ma'am. Good afternoon, Dr. Ambade sir, and good afternoon, all of you. It is my great pleasure that I got the chance to introduce Dr. Balram Ambade sir. Sir is currently working as an associate professor, head of Department of Chemistry at National Institute of Technology, Jamshedpur. If we talk about the qualification of sir, then sir completed his PhD in 2010 from Pandit Ravi Shankar Shukla University, Raipur, Chhattisgarh. Then sir completed his postdoc in 2012 from IISER, Bhopal. Sir is the recipient of numerous awards, including Young Scientist Award, to participate in Open Science Conference by Institute of Atmospheric Physics, Chinese Academy of Sciences, Beijing, China in 2014. Sir got Marie Curie Award by the European Commission to attain dynamics of diversity in the globalization era, Eurovid 5th conference in Italy in 2009. Sir also got the Marie Curie grant by European Commission for a participating training course Physics and Chemistry of Air Pollution and their effects, field course and data analysis held at Haitiala Forestry Field Station, Finland in 2008. Sir got SERB Early Career Research Award and many more awards. Sir has completed 4 projects till date and 2 projects are ongoing. Sir worked as coordinator, chairman, and convener in different workshops, national and international conferences. Sir has published 4 books, chapter, and 56 journal papers on international journals. Till now, 5 PhD scholars, 11 MTech, and 26 MSc students completed their thesis under his supervision. Sir is the associate editor of Elementa Science of the Anthropocene Journal. Sir was the invited speaker in many national and international conferences such as at NIT Jamshedpur, Pandit Ravi Shankar Shukla University, and also in our college. Today, in this seminar, sir will give a talk on intellectual property right and research methodology. I heartily welcome you, sir. Now over to you, sir.
Yeah, thank you so much.
Okay, sir. Welcome.
Yeah, thank you, Thomas ji. Okay, so may I audible to you?
Yes, sir.
Okay, thank you so much.
Yes.
Yeah, thank you for giving me wonderful chance. Let me share my screen. Okay. Fast disable participant screen sharing.
Yes, sir. Yes.
Yeah. Host disable sharing my participant screen. Yeah, host, please disable participant screening so that I can share my PPT. Yeah. Okay. Yeah, thank you. Thank you so much. Okay, thank you so much. 1 minute, please. One minute, please. My screen is visible to you?
Not yet, sir.
My screen is visible to you?
Now it's coming, sir. Yeah.
Yeah. 1 minute. SIP. Thank you so much. So I thankful to principal and all faculty members, researchers, and other students and colleagues which are attending to this seminar on IPR and research methodology. So I will talk about IPR. Okay, so I think my PPT is visible to you all. 1 minute. Now it's complete.
Yes, sir, it's visible.
Oh, wow. Thank you so much. Okay, so I thankful to the institute, and let me speak about intellectual property rights. Myself, Dr. Balram, working as associate professor in NIT Jamshedpur. So IPR, if you can just type Google in IPR, so it will be just take you Institute of Plasma Research. So here we should understand what do you mean by the IPR. So the correct another full form of IPR, that is intellectual property right. So we have to just discuss what is intellectual, what is property, and what is our rights. What are the rights which has given to us? Okay. So objective of today's talk is to give, I will provide here the general introduction of intellectual property right and their role in technology transfer. And here I have planned this presentation with the rationale of protections, and we are having the different kinds of IPRs which should be addressed. So IPR and licensing, IPR in agreement transfers, IPR in technology transfer, IPR in section from one section to another sections, that I will have to highlight. So we have to just tell about the introduction about IPR. So we have to tell about the IPR. I means intellectual, P means property, R means right. So intellectual, we have to take intellectual after some time. First we have to take property. So we are having different type of property. Suppose I am living here. So my phone is my property. This is my phone. This is my property. I have a car. I have a pen and furniture, dresses. All these addresses all are my property. Okay. So these are called movable properties. we are having immovable properties, just like land, our buildings, just like the springs, whatever immovable properties we have, house, we are having immovable properties. It cannot be moved from one places to another places. So we have to just talk about the intellectual property. Intellectual property is type of literary work or invention, discoveries. What are the discoveries? What are the research has been done? And this research should be, that is my property. Suppose some my brain is working extra, and I am just producing lots of things from my brain. Suppose I am discovering new medicines through my brain. So that is my intellectual property. So we have to just discover the things are the new fundamental origin, so that the novelty of that should be highlighted. So those are called intellectual property. So here we should have to directly, I will tell about the IPR. So IPR are mainly 4 types. Okay, first is copyright. Copyright, we suppose some author has published his some papers, research papers. So I will have to not copy same it is. His lines, his words, his sentence should be not copied by me. So I will have to publish some books. So I will think that this is my original books. So I will not give any person to write similar things. This is my that I originated from my mind. That is from that originated from my discoveries. So this is for me. Okay, so if somebody will copy this, then he has to take permission from me. I am the owner of that book. Okay, so similarly, the copyright is very essential for these days. So sometimes we are doing some patents. Patents means we are publishing some suppose novelties there. So we are publishing the papers, and some machine tools or engineering tools we have some discovered. So those things should be patented. Suppose the idea is new, unique, so nobody can copy this. So I will have to take patent applications and get it patented. Okay, so patent is published patent, and patent may be the awarded patent. Like that, we are having the one special numbers that may be for protection for 10 years or 20 years, whatever the requirement is there. So I will patent that technology. So similarly, the trademarks is having, we have to say, suppose the Coca-Cola is having different type of trademark. We all are drinking any type of fruits or branded items. Those are having the trademarks. They are having with a unique compilations, or some unique stickers are there, unique logos are there, unique designs are there. So that things are there. So that is called trademark. And the trade secrets, suppose the trade secrets is there in any particular industries. So it will be differ from one industry to another industries, and one product to another product. So we are having all those different types. So very simply, I will tell you what doing by all those things. So we have to just start it, and suppose what doing by the intellectual property right. Okay, so some idea we are having, some ideas. Suppose I am having some ideas. So I was just thinking this one. Suppose I am just doing experiment. Is a chemist or is a physicist? We are doing some experiment, and we are having some ideas. So this idea will protect us. Okay, this idea we have to protect. So these protections is called as, this is my property. So that originated from my brain. So that is called intellectual property. So we are just tell about the authorship, our trademarks, our patent, our novelty of any work. Similarly, the protections and copyright are some brands are specials. So that brand should be protected. So all are covered under intellectual property right. So these are my property. I should protect these properties. Okay, so government has given some provisions so that technology transfer should be in unique way. Okay, it is your property, and you have to you are having the right to protect our property. So the nature of property means the creation of human minds. Okay, so we are telling that some peoples are intellectual peoples. We are thinking about these peoples are intellectual speakings. They are having very good capacity to understand any phenomenon or any theorems or any depth of knowledge. Okay, so that is always called as intangible properties. Okay, we cannot having somebody is having special knowledge on particular fields. So that is called intelligible property, and this exclusive rights of the statute, and we are having some time bound and some terrestrial has having also effect on that particular nature of intellectual property rights. So I will just tell you about the definition of IPR, because many times we are seeing that IPR. So we should understand what do you mean by the IPR, what do you mean by the intellectual property. So intellectual property includes the following things. First is it includes the literary. Some artist, it is having a special type of art, and some scientific work. Suppose I am writing some papers. There I have just given is a topic which is very essential, and that is a very depth of knowledge. So those things should be protected. So we are just invention in human behavior endeavors. We are having the scientific discoveries, or we are having the industrial designs and trademarks, service marks, or commercial names, designations are theirs. So that should be protected, and it had been not in unfair competitions. So we are having the other rights, just like the industrials and the scientific, literary, and architect fields. And these are the definitions given by the intellectual property rights by the World Intellectual Property Rights Organizations. Okay, so this was the organizations who control the total world intellectual property rights. So we have to just suppose some properties there that is in my hand, some properties that is my hand, some intellectual properties there in my hand. So what I can do from here to I will have to some creation. We will create something. Okay, then we have to just suppose some creation is from my mind. So we can apply for protections. Okay, then I will have to apply these things through application in government portals. Then we have to just get one protections of this. So this is my suppose I want to open new shop, a new business. So what I can do, I will create something. Suppose I want to discover this. Suppose I have these mobile phones, and these mobile phones. I want to update this version of this mobile phones. So what I can do, I will have to think some things I will have to just think about the design. Suppose this much size is there. So I will have to design this mobiles in just like Flipmat, so that I can do anything. It will be not harm to anybody, or not stress to anybody. I can fold my mobiles. Suppose that technology is with me. So what I can do, I will apply this creation in the government portal. Then I will get protection from the government agencies. Then I will start my business. So that I will, whatever the money will be get from the purchase of these foldable mobiles. Okay, I will get those royalty. So you will get easily royalty in or you can just purchase, you can just send or purchase, or you will have to sell this particular technology to the another businessman if you want. Okay, so patent sometimes that is got intellectual property right patented or not patented. That is the different things. So we have to just discuss we have to just because as an Indian we should understand where is our country and what other countries in world we are, how much patents we have published and how much intellectual property rights we are having, and due to these intellectual property rights it depend upon the gross GDP of any country. So India is among top 10 countries in the intellectual property rights. So because in India we are having the very special quality of Indians, as well as the mind of Indians are very sharp. So we are in top 10 countries. So we have just see. So this is very important diagram. Here it will be tells about the China has that. Here you can just see x-axis and y-axis. Here you can just see the country's name. The country's names you can just see the China, USA, Japan, Korea, then Germany, India, etc. So here the number of applications. So how much patent applications are there in worldwide filed patent files? So you can just see that China is having that these two the red lines says the residents, and this yellow line tells about the non-residents. Okay, so we can just we can just see here. Okay, so what happened? Okay, yeah, it is. Oh, okay, so here is our position. India is here. You can just see India. Here the residents and non-residents of India, how much they are filing the patents. These are the data of 2018. Okay, so the other countries just like China, USA, Japan, Korea, they are having more technological transfer, or they are having more IPRs in terms of patents. They are filing applications. So we have to just think about the other companies in India. We are just thinking that which industries or institutes is filing maximum patents. So here the SRM University has filed 32 patents, and here the Wipro Limited has filed 125 patents. Okay. So Tata Consultancy is it's second largest filing institute in India. Similarly, we are having the applications in each year. We have just seen the patent, the trademark, and copyrights. Okay, so here we found that the patents, you can just see it is slightly just like 50,000. Okay, then this is the trademark. Trademark is highest filing, or number of trademarks is more filing as compared to the other two, that is patent and copyrights. Okay, we started copyrights from 2016-17, and we are just continuously the copyrights is also increasing in India. Okay, so now we have to just see the India patents filing grow despite of pandemic periods, because our country has faced COVID-19. So during those time also the India in top 10. So India is in 8th positions overall. If you can just see the intellectual property right in 2020. Okay, you can just see the China, US, Germany, Japan, South Korea, France, UK. After that, our number is there. Okay, so so we want to train the young researcher like you, which will become forward from the remote areas and contribute some filing of patents, so that our country will get more number of patents, applications, more number of knowledge, more number of technology transfer, and so that our GDP of our country will increase. Okay, we will become richer country if you can file more number of patents, if you can utilize your brains very sharp. Okay, so this is our number, that is 8th during pandemic periods. So we have to just think about the very essential things, that is trademarks. So trademarks, we are having the trademark. Suppose this is our Coca-Cola. You can just see the shape of Coca-Cola, how the design of Coca-Cola is there. What is the name is there? What is the shape is there? The shape of bottle is specific. So these all are called as trademark. Okay, some symbol is there. Okay, some orange symbols, the color code is there. So these all are having the trademark. So you cannot change the trademark. Once by seeing up this car symbol, you can just think that this is this car. You are in your mind, it will be quickly understand that our car is this. Okay, by just like Maruti, a Tata car. Okay, a Tata Nano. We are having the special type of design. Okay, we are having the special type of designs, and which cannot be changed. And by seeing or looking up the design, you can easily judge which car it is. Okay, so they have protected their shape, size, name, logo, slogans, etc. So these all are called trademark. Okay, so trademark in India, we are having the number of filing of trademark is very high in these times. So I think let you can just see the trademark, very beautiful trademark. These companies are having very beautiful trademark. Suppose like DHL, suppose like Castrol oils. Always you can just see the Castrol will be written like this only. They are not using the another type of C. Okay, they are having some special codes and colors. Colgate, suppose they are writing the Colgate, so this will be like this only. So these are having the special type of color codes. These are having the special type of design of name. Suppose they are writing that Tata, TATA. Okay, so suppose they are writing just like this. So they will use always it is. So these are called trademark, so that nobody can copy. I am the only owner of this, and if another will copy, or anybody want to copy, then he has to take permission from me. So I am the owner of this. Okay, so these are the McDonald's, KFC, Subways. So pizza is very tasty. So you can just see the pizza is having also a different logos. So which one is this pizza or that pizza? So all pizza is having the different type of logos. Okay. So we can just see the trade secrets. What secrets are there in trade? Okay. So it is also very important points. So trade secrets, we have to just think about what is the confidential is there. What may be the formula there? What is the process to approach that particular techniques? We have to protect. How much financial liabilities is there? How much business we have to take? Then the knowledge of this business. Then we have to assess. Then instrument. Then we have to just take it in privacy. Okay, so because this privacy, so that suppose some software is there, suppose some software is there, suppose antivirus is there, it is having a special type of code. Okay, suppose Microsoft is there, it is having a special type of code. You can purchase from me. I am the owner of that. I have designed this one. So like that, you can say this one is specific done by particular intellectual person. Okay, so those are called trade secrets. Trade secrets, suppose some softwares, it is having a definite codes. We cannot assess the software without entering some particular codes. So that is called trade secrets, because some confidential is there, some privacy of the code is there. So that is called trade secrets. So these four terms are very, very essential. First is copyrights, second is patent, third is trade secrets, and fourth is, we have already seen this one, trademark. Okay, so we have to just our study, we have to just think here. So trade secrets is the commerce or business formula. So all are related with industries. Industries peoples are mainly doing this type of business. For any business or for any financial things or investment or protections or the finance restrictions or a type of confidential secrets, privacy. So these are the very unique words. Okay, so here we are having the intellectual property rights. So intellectual property rights. So we have to just think the contract between what done by the principle of the intellectual property right. It is the contract between creator and sovereign state. Okay, we have to protect from revelations. We have to balance from the creators and public interest. So we have to just think what are the things are there. So major intellectual properties, we are having a copyrights and related rights. Suppose I have wrote some books, so nobody can publish these books. Okay, similarly, the industrial property, we are having the patents, industrial designs, we are having trademarks, we are having the geographical indications, we are having the different type of layout, designs, or topological integrated circuits, are new plant varieties. Suppose we have suppose two plants are there. We have hybrid. We have to hybridize it the problems, and we have sometimes the born of the new plant or discovered the new plants. So it is having the new protections of plants varieties. So many things are there in intellectual properties. So we have to just think the intellectual property laws of India. Suppose we have to copy from anybody. Suppose some books are there, some papers are research papers are there. So we have to take some part of research, under research papers are right. We are writing or copying the similar type of research papers, are his words, are his technology. So we have to take permission from him. Otherwise, we are having special laws to protect this, protects this knowledge, protect these articles. Okay, so that is the act, our government promulgated certain type of act which are necessary to the particular copyright. So in higher education, we are having the Copyright Act, because in higher education, suppose some books are there, so nobody copy that books or papers, are research scholars. Okay, so that are the Copyright Act of 1957 in higher education. The Patent Act, that is specifically for the industrial policy and promotions. Okay, similarly the Design Act, again it is related with the industry. Okay, and Trademark Act 1999, so that is specifically for industrial and policies. Okay, geographical indications of goods. Suppose we have registrations and protections are there. So it is formulated on 1999. It is also for industries. So lot of things are lots of laws for the industries. Similarly, we are having the semiconductor integrated circuits layout designs. It is the designs comes under the information technology, and the Ministry Department of Information Technology Department is hearing these things, take care of these things. So the next is the protection of plant varieties and farmer rights. In 2001, it has a new act which is promulgated on 2001, and it has controlling by the Ministry of Agriculture. So it is related with agriculture, because the plant varieties are there, different varieties of plant, hybridization of plants, and the new development of plants are there. So it is there. So we are having the certain laws. If these laws are there, So this law protect this particular IPR. So copyright and related rights. Okay. So suppose we have to see the original, literally a dramatical musical and artistic work. So some ideas are there. Suppose you can just see two film. Suppose one film is there, second film is there. So two film, we don't have similar type of dance. In two film, we don't have the similar type of dialogues. You can compare the two films because films are very, it is very interesting. We are looking many fields. So you can just compare the two films. One film is showing different dialogues, another film is having the different dialogues. Okay, the song of two films are different. The dance of two actors are different in two films. The scenery, even the sceneries of two films are different. They are not copying the same things. They are not copying the same designs. They will not go for the similar type of activity. So the sound recording of two particular films are different. Okay. So this because of the copyright. Suppose you will copy my certain voice, or you can copy my styles. So I can file action on you like that. It is there. Suppose some song I composed. So another will compose his song with his own ideology. He will not copy same to same of mine. Okay. So these are the rights. So let's why we have to intellectual property rights. So let's one word we have taken the right. What is rights? We know the fundamental rights of constitutions. So similarly, the rights are there. We are having the two kinds of rights. Okay, first is moral rights. Okay, moral rights means we ethically say that suppose this is his books, or it is his articles, so I will not copy his articles. So that is my morality. That is comes through the parental cares. It comes through the ancestors, comes through the fathers, because it tells about the surroundings. It tells about the morality. This is my moral duty. I will have to not copy. This is other things. So this is the protections of personality of author. Okay. So second right is economical right. To bring some economical benefits are the some to take over the some in financial benefits. Okay. So these are the two types of rights. So we have to just think the moral rights. We have to just take. We have two types of rights. First is moral rights, and second is second was the economic right. So first we are taking the moral rights. What is our moral rights? So right of authorship, right of integrity. Okay. So digital manipulations, no right for display. So these are having the moral rights. Okay. So we have to just think what are the economic rights. So economic rights, we have to just take it and we have just compiled into the economical right 1 and economical right 2. So what is the economical right 1? So here the right of reproductions and the making of copies and editions of novel, the storage of computer memory. Okay. The right of distributions are issuing of copies, and the right of communications to the public. Okay, some public performance is there. Some international internet communication is there. So this type of words we are having. So this is protected through economic right 1 and economical right 2. What are the protected? Here, our right is the adoption rights. Okay, we are converting from just literary to drama. Okay, so some picturations, suppose somebody has written some things. So we have written some things into different picture styles, pictorial styles. So that is a comics format. Suppose some books are there. So we have to, whatever we understand, we have to make some books. Okay, those rights to make cinematograph or sound recording, translation rights, or parental rights. So these are the original architect's works, and we have to rescale those rights. Okay, so we have to just see the ownership of those rights. So who is owner of those? Suppose some literary is there, so some author is responsible for that. Some drama is there, so we know who is play the drama. So those are the responsible. Suppose some music is there, some song is there. So the composer is having the honor of those rights. Some architect work is there. So architect work, suppose I am having a beautiful drawing. Okay, so I will draw very beautiful pictures. So as an artist, as a painters, okay, or sculptures. So I am the honor of those things. Suppose very beautiful photographer I click from natural beauties or any very unique photographs. So I am the owner of that. So a particular photographer is owner of that photograph. So the author of computer program, the person who developed or created that particular software is the owner of that program. Suppose somebody has invented some new software which can translate from Hindi to Chhattisgarhi language. So he is the person who can the honor of that particular. Okay. Suppose some cinematograph films are there, so producers are there. Some sound recordings are there, some producers are there. So they are having a different type of honors. So honor is having some rights. Okay, the course of employment. So the employment by newspaper, they are just recruiting some exceptions or some honors rights. Newspapers are magazines are publishing rights. They are giving to the other one. And similarly, the photographers is the honor of that particular photos. Okay, some painters honor of that particular paintings. Cinematographers in particular cinemas. So these are the valuable persons. If you want to take some articles from there, some things from their scenes from cinematographers, so you have to pay some money for that. Okay, so lecture delivered in public. So suppose those things are delivered. So that is a person delivering the government work or governmental things are also protected there in government agencies. Okay, so we are having the whole world is having the international organizations which can protect our laws. So that is called intellectual organization, that is IWO. Okay, so intellectual organizations is there. So and it is protected internationally. Suppose the work of apprentice to teacher. If teacher write a book, then teacher is because of employment. He will have to teach and not write. Okay, so similarly, many things are there. So you can just see the question paper. Who is the question papers setter? Suppose some professor or teachers has just setted some question paper. So they are the honor of that. So they have the honor of that particular things. Okay, some encyclopedias there. So some who has collected or edited that particular encyclopedia. Okay, so those are the honor and they are having the exceptions rights. Okay, the music under contract of film. So film producers are the honor of those particular rights. So security in Copyright Act. So formality free protections. So voluntary registrations we are having, and the registration does not have matter of law to establish whatever registered in the fact, and the law of copyright is subject to matter of governmental court and it has been protected. And duration of copyright, you can just think how much duration is there. So it is for, suppose some musical or artistic work published during lifetime of author. So we can just say that is protected for life plus 60 years. Okay, till the we are having the regulations. In that regulations, we are having this particular things, life plus 60 years protection is there. So all other works 60 years from the date of publications. Okay, so government, sometimes some books are written which are very, very essential. So government itself is coming to protect those books. Okay, so some sounds are there, some intellectual things are there. So some dichotomy is there. So government is protecting all those, some photographs, some cinemas, some sound recordings, all those. So related rights, you can just see the performance, broadcasting organizations. So these are the law of communications. Okay, so rights granted under the law of communications for the work of public. Okay, so we have to just see some messages are there. Okay, so rights of broadcasting organizations. So broadcasting production rights, suppose the broadcasting is there, so they will have to protect themselves. So rebroadcasting, recording and communicating to the peoples for broadcastings, the durations till now, till these regulations we are having that duration of 25 years. Okay, so we have to just discuss about the patents. Patents, which one is what is the patent and how we have to patent any product, what is the inventions, okay, what is the new way, what is the new novelty, what is the new technology, what is the invention, what is the technological solutions which can solve the industrial problems. Okay, so it will be gives a particular technology which can solution the government problems, government as well as the industrial problems. Okay, so technology, the patents we have, that is limited monopoly rights granted by the states, which can enable the inventor to prohibit the another person from manufacturing or using, selling a patented product from using the patented process without permissions. Okay, so the period of patents are 20 years. It has fixed due to these regulations. It may be extended in time to time or depend upon the product to product. Okay, we have to just see how the patents are, what is the history of patents. Okay, so in 500 BC in Greece, first time some intellectual persons. Hello. Okay. Yeah, in history of patents, we are having, if you can just see the history of patent in Greece in 500 BC, they are thinking intellectual professions were coming together and thinking how to, they are thinking that we have invented some things and this is just bypassing, and other peoples are applying similar things. Other countries were using the similar things. So they are just thinking, we have to just apply some technology as our government will be interfere here. So the people, community, or society have themselves have made some societal society, and those society is protecting some things. So similarly on Europe, it has just in 1700 Europe, they are just having the lots of new research and new discoveries. So during those days, they want to take it in the appropriate platform. Okay, therefore they have just uses the patent technology, and they are later on in Europe only, the United Kingdom and US, they are having the Office of Patent Office. And after the independence of India, we are having also patent office, and our patent office also running very well and protecting all the intellectual property rights. So we have to just think the patent system supported by US economic growth, because patent is very essential for the development of any country or economical growth of any country. I have already told the GDP of any country depends upon the number of patents. So you can just see in 1850 to 2010, the number of patents is increasing. Similarly, the economical growth of this particular country is also increasing. Okay, so more number, you can just say sometimes if more number of patents, more number of technology transfers, more number of applications of patents, more GDP, because we will have to invent the new things. We will have to invent new business, and it is having the some industrial applications. So by this, we will have to get maximum benefit from those. So it is directly proportional. Your number of patents is directly proportional to economical growth of any countries. And US is much, in US having the more economical growth because of more number of patents, you can say. Okay, so two categories of patentable inventions. First is, two things are very, very important. First is the process. Which technique? Suppose that metro train we want to install here in India. So what is the technology of this metro trains which can fly above the earth? Okay, so what is the process? What are the technologies? What is the scientific activities? Okay, those things are called process. So what things are there? What is the compositions are there? What synthesis is there? So which activity we have achieved? So that is called process. And second is product. So second is product. So two things are patented. First is process, by which process we have achieved this particular goal. Second is what product we got, ultimately product. Okay, so suppose some medicines we have developed for curing some heart diseases. So that is my product, by which activity I have discovered this TB medicines, or tuberculosis medicine, or carcinogenic treatment medicines. So that is my process. Okay, so that process and product are very essentials. So sometimes we are thinking that can everything will be patented? If yes, then we can patented anything, or we can patent something only, or specific thing only. So the inventors were thinking, so the technology we have developed, the product, our process, so that is meeting with our criteria. Suppose I have developed new things. So the new things I can patent or not patent, it has already discovered by some things else. So we have to just think for that. Before that, we should understand the novelty. What is the novelty? What is the new in this particular product, or what is the new in this particular process? Okay, then we have to just think what is the industrial application of this particular product. What is the benefit to the human society of this particular process or product? So if it can follow these particular things, two things. First is novelty. Second thing is non-obviousness, means nobody has discovered these things. Third is it is having some industrial applications. Okay, so industrials is how it will be solve any problem of industry. Okay, or how it will be help to the industry. So the condition for patenting anything. So invention means the claim of inventors. So, okay, it is first time it has discovered. Okay, so this first time it has discovered. So what are the innovative steps? Invention would be not obvious in persons in ordinary skills of art. Okay, so the industrial applications means innovations can be made by the using of useful or practice or some purely intellectual things. So these are the conditions for patents. So 3 conditions of patents are very essential to publish any patents. Okay, so we can apply the patents to the with the help of patent writers, because we are writing some things, so that is different. Patent writer is having some technological or good words. They are choosing very technological words. Okay, some specific word or legal words you can say. Okay, so the grant of patents, we have to consult the some patent patent writing persons. Then the patent writing persons at the particular industry or particular institute will check the novelty of your work. He will tell that this is patentable or not patentable. Okay, so after that the patents are granted by National Patent Office. After we have to apply this one, then this patent will be published from the Patent Office of India. So suppose the IPR India, it has published this, the special portal is there. So they will just send for patent examinations. Before publishing any patents, we have to just take for some examinations. What reviewers will say, our expert will say for about these patents. Okay, so the in India we are having the pre-grant and post-grant for the patents. Okay, here we should know the foreigners can also apply for the Indian patents. Suppose the Indians can also apply for the foreigners patents. They are having some links. Through those links we can also apply for the US patents or Japan patents, whatever you want. Okay, so okay, so many things we can patent or many things we cannot patent. We are suppose suppose the technology is there, technology we can patent. Suppose we have just which is not patented. Okay, some a substance is obtained from a mixtures resulting from the different properties or components or process producing such substance. Suppose you can just see the paracetamol is a tablet plus a brufen, a small another tablets. So both are antipyretic. Okay, so we have to taking together and mixing together. We are doing some small type of research over there, and a soft drink just like mixture of sugar and some color in water. So but the mixing is having the resultant of synergic properties, which is having the ingratable, maybe patentable. Example just like soap, detergent and lubricants. Okay, so which can patented or some things are not patented. So here I will have to finish my lecture very soon. So applying of patents, we are having the specific site, that is Indian Patent Advanced Search System. There you can apply for any patent. Okay, So what is the you have to just file the patent, then the what type of patent you are having, the utility patent, it is design patent or plant patents, you have to fill there. Then you will having the decide that is the file of provisional patent filing you are filing, or non-provisional patent you want to file. Okay, or these things. So this is the government portal from which anybody can file the patents. Okay, so the department for promotion of industries and internal trends, it comes in the government of India. These are having the designing patents. This is the patents, design, trademarks. They are protecting all. So government having promulgated some certain laws, and these laws protect those particular patents, designs, and trademarks and trade secrets. Okay, so we are for the patenting anything, we are having the certain fees. So applications for the grant of patents, you can just go through this government portal, that is intellectual property right in India, IPR India, and you have to just search this page, and if you want detailed the fee, the forms, or the applications, how it is, so you can just download and you have a read. So industrial design, suppose the shape, configurations, or pattern, or ornaments, some colors, lines, some many designs are there. So some industries having particular design. Suppose my boiler design is like this. Some power plants, they are having the specific particular designing of their equipments. So some chemical or mechanical are separate or combined chamber, any hoods. So these all come under the industrial designs. Okay, so this can be patented. Suppose a particular consumer product, you can just see the designing of particular product. Suppose it is just pen is there. Suppose some company pen is there, so it will be designed like this. Some watch is there, it will be designed like this. So they are having the particular designs, and they are just copyright of those designs. Okay, some pharmaceutical products. Suppose they are coming there. Suppose you can just see here the tablet. These are coming in red and yellow. So it will be always like that. They have just designed this particular pharmaceutical product. Some needle are particular capsules, are tablets, are injections. So are bottles, small bottles, foils. So these are having the special designs, and these are protected by the government. Okay, similarly, the textile and jewelry, we are having the different type of shape of jewelries, different style of jewelries, different color of jewelries, different designing of jewelries. Okay, how this will fit, and what is the size of the particular ornament they are using. So all is protected. So the different type of trademarks are there. Okay, so many things are there. Okay, so we are having the international organizations for intellectual property rights. 1 minute. Yeah. So international organizations in intellectual property rights, that is World Intellectual Property Organizations and World Trade Organizations. These are the two institutes which are take care of the patents at international levels. Suppose all patents office of all countries are comes under this World Intellectual Property Right Organizations, and suppose some dispute between two states or two countries or two synthesis or two drafts are there. So the final concern which will be gives the noting on the particular patents, so that is in world level, that is World Trade Organizations and Intellectual Property Right Organizations, and these are the two organizations. Okay, thanks. Thank you all. Thank you for inviting me.
Thank you so much, sir. Now, after this excellent lecture on IPR, I would like to ask if anybody is having any questions regarding IPR, you can ask to sir. If anybody is having any query, you can ask to sir.
Okay, I think there is no question. So even after this, if you can just read the patent, then you can just email to me. My email is bambade.km@nitjsr.ac.in. Okay,
Thank
if you
you,
are
sir.
having some questions, then you can just email to me. I will sort out all the questions.
Okay, sir. Now we would like to call Dr. Samiksha Chandrakar ma'am for vote of thanks.
बहुत बहुत धन्यवाद मनीषा मैम। और आज के द्विदिवसीय इस राष्ट्रीय सेमिनार के प्रथम दिवस के प्रथम सत्र में हमारे बीच संजीव बनर्जी सर IIT भिलाई से, और इसके पश्चात डॉक्टर बलराम अंबाड़े जी NIT जमशेदपुर से, और उन्होंने जो ये विषय पर अपनी गहन जानकारी हमारे साथ साझा की, उसके लिए आयोजक मंडल की ओर से और पूरे महाविद्यालय परिवार की ओर से अंबाड़े सर आपका बहुत बहुत धन्यवाद। और आशा है कि भविष्य में जो भी इससे संबंधित प्रश्न होंगे, क्वेरी होंगे, हम आपके साथ इसकी जानकारी जो है साझा करेंगे। बहुत बहुत धन्यवाद सर आज के इस लेक्चर के लिए।
Thank you so much.
Thank you, Ambade sir.
Yeah, thank you, Yadu sir. Thank you.
Excellent lecture on IPR.
Yeah, thank you, Govardhan sir. Thank you so much.
Pleasure to talk with you with online mode. Next time, we hope to join physically in this institute and deliver a nice talk on our student. So again, thank you very much, sir.
Yeah, thank you much for this opportunity. Thank you so much, sir. Okay. Bye.
आइएगा तो फिजिकली आपका लेक्चर रखेंगे।
Okay, sir. Thank you so much, sir.
यहाँ
Thank you
जुड़े
for this opportunity, sir.
ठीक। Thank you, sir.
Okay, sir.
Next session will be started after 10 minutes. ये YouTube पे live streaming होगी इसकी।
Sir, may I disconnect myself, na?
Okay, sir. Okay.
Okay, I am stop sharing.
आपका सम्मान बचा हुआ है सर, आप जब फिजिकली आएंगे ना तभी आप दे पाएंगे अभी हम लोग।
ठीक सर। Okay, I am leaving. Bye all.